Dr. Dominic Ayeni provided an update on Operation Recover All Loot, the government's initiative to combat corruption and recover misappropriated public funds. He emphasized that only cases with robust evidence would proceed to court, resisting external pressures for hasty prosecutions. Well, Dr. Ayeni also disclosed that oral committee, it has identified approximately $21.19 billion in potential recoverable funds from illicit transactions and undervalued state assets and their sales. Notable cases under investigation include the National Cathedral Project, the Power Distribution Service scandal, amongst others. In a specific instance, the Attorney General revealed that Juan Eduboahin, in collaboration with his wife, they allegedly embezzled up to 39 million cedis from a government agency. Well, Dr. Ayeni reiterated the government's commitment to transparency and accountability, stating that only cases with solid evidence would be pursued in court. Let's take a listen to what the Attorney General, Dr. Dominic Ayeni, some excerpts of the press briefing yesterday, and then we'll begin to dissect and sink our teeth into them. We have all the experts lined up for you. Remember that we'll be speaking with the Deputy Attorney General. We also have some anti-corruption experts, some anti-graft campaigners, I should say, also on the bill this morning. We will recover our country. But first, here is Dr. Dominic Ayeni. He is the Attorney General of the Republic of Ghana.
The investigations also established that the proceeds from the suspects' activities were used to buy significant landed properties and other assets of considerable value both in Ghana and elsewhere. Now, ladies and gentlemen of the press, my fellow countrymen and women, I want to give you a sample of what we have discovered so far. We have tracked most of the assets. The properties that are in their names, their joint names, or sometimes in their, in their individual names, are as follows. We have number 2 Stream Park Drive, Mayfair Estates, LA, that is Accra. For that, they deposited, and we have the deposit slip as well as the receipt from the estate developer, $1 million United States of American dollars. Number 6, Edith Avenue, Mayfair Estates, Accra. Deposit 500,000 United States of America. That's American dollars. That's the initial deposit. All right. Then we have number 7, Edith Avenue, Mayfair, 200,000 United States of America. The property. Number 8, Edith Avenue, Mayfair Estates, Accra, 97,815 United States of American dollars was deposited for that property. But we are sure that other cash payments were made to complete the purchase and then the transfer of ownership. So we are tracing all those documents. Number 9, Edith Avenue, Mayfair Estate, 270,000 United States of American dollars deposited, initial deposit for the purchase. Number 10, Edith Avenue, Mayfair Estates, Accra, 150,000 United States of American dollars deposited. Now, he also owns a company known as Vertex Properties. Vertex Properties. And we've traced the proceeds of crime to Vertex Properties also. They have, Vertex Properties owns 27 houses located at Oyarifa. Each house costs, an estimated cost of 295 thousand United States of American dollars. We also know that they have 2 properties in London that we are tracking, and I'm going to trigger the mutual legal assistance between the United Kingdom and Ghana for us to be able to lay hands on those properties. Now, we also know we've been following the bank transactions very closely, and we know that on February 11, 2020, the made a 16 million fixed deposit from the payment received from BNC Security. This was from the initial payment of 27 million 100,000 Ghana cedis. On April 3rd, 2020, Mr. Dubois alone withdrew 7,250,000 Ghana cedis, okay, in cash. He withdrew that in cash. This payment came out of the second transfer of the 21 million from BNC National Security to BNC, his private, company. On April 24th, 2020, 1.5 million cash withdrawal was made. On the same day, he made payments to a real estate company to the tune of 1,566,000. So you see the coincidence, okay, of the transactions that were taking place. Then February to September, out of the 49 million, which was transferred from BNC National Security to his private BNC, about 99% was withdrawn by him personally. And they were largely very large cash withdrawals. And we believe that those were the withdrawals that were made for him to make the deposit for the properties that I enumerated above. We are working diligently on several dossiers that will shock the conscience of the nation. If what suspect Edu Boahen and his wife has done is like a thriller in Manila, please brace yourself for a rumble in the jungle in the next few weeks. Thank you very much, ladies and gentlemen. Now, I also want to take this opportunity to tell everyone in public office who's listening to me that if you do what suspect Edu Boahen did, now I will come after you. All right? I will come after you. I'm not going to wait because I have the authority of Mr. President that if you engage in anything like what Mr. Edu Boahen has done, or any act of criminality, I will not wait. I will come after you. So this is a warning to everyone. Thank you, ladies and gentlemen. And
this morning, let's get right into it. We have the Deputy Attorney General on the line with us. We also have a private legal practitioner also joining us on the phone lines this morning to delve into the matters and the reactions that they have sparked since the Attorney General and Minister for Justice, Dr. Dominic Ayene's press conference yesterday. First, to Dr. Shremsai, thank you so much for your time with us on the program. The Attorney General, your office has been in the news over the past couple of days in relation to the work you're doing to recover looted funds belonging to the state. The latest coming from the BOG's governor's residence search that the minority is still calling a raid and the subsequent discoveries that have happened. From where you sit as the Deputy Attorney General, could we have approached any of these in a much better way? For instance, the search at the BOG governor's residence.
Definitely, when you look at the issues of law enforcement and human rights, there is one thing that everybody would agree with, is that there can always be a better way to protect human rights. So I would not sit on national television and create an impression that whatever we are doing or what we will do is the best. So the very concept of human rights protection or law enforcement and the rule of law is it's something that we always strive to get better at. So from that perspective, yes, there can always be, a better way of doing things.
Let's backtrack a little bit to the search at the BOG governor's residence, where some of these incidents are also coming out from. There are concerns that the minority is still raising, for instance, that the search was not carried out properly, although there was a search warrant. Have these concerns come to your notice?
Of course, we have. These concerns have come to us as state institutions, we do not only deal with formal ways of consent, we also monitor what happens on the media, in the media, on social media, in parliament. So we are definitely aware of the concerns that have been, raised.
Looking at the matters that have come out as a result of the search, for instance, the minority is saying that some amount of money, some 10,000 cedis was taken, some jewelry belonging to the wife of the governor was taken. When it comes to such processes, when a search warrant is obtained and the search is carried out when the court is aware of all of that, how should it properly be handled?
The minorities' complaints are not general complaints of how things were done. They were very specific. They made very specific allegations. They said jewelry were stolen. They said it was a raid. They said monies were stolen. I think at a point, they also said that food was stolen from the kitchen of the home. In fact, they called the national security operatives who carried out the search. They described them as hungry. So we are not here dealing with people with an allegation of general criticism of how things were done. We are dealing with specific allegations of criminality. In that regard, we have taken our time as a responsible state institution to, first of all, we took our time to, usually we are briefed before these exercises are done, because it is under our authority. We applied for the warrant, so we are briefed before it's done. We advise on how it should be done. We go to court to secure the warrant, and when the operation is done, we are immediately briefed. If a brief is not sufficient and we see that there are other areas that we need further briefing, we ask such briefing to be done. In this particular case, we were briefed twice, because after the first briefing, you remember last week I came out to say that it was done in accordance with warrant, and the manner in which it was done was in accordance with law. Yeah, so that is what we said. But when the specific allegations were made, we did another round of briefing to be sure that what we did, the first briefing was done, was not misleading. We spoke to our officials. We asked for evidence of what they did in terms of recording, so certain things were, so we did further briefing. We took further briefing from them, and yes, the briefing showed that the search was done and the basic rules of searching were complied with. So, for example, if you want to conduct a search, the standard procedure is that on your arrival at the premise, whoever is in charge of the premise, you have to introduce yourself and show your ID or identify yourself. If the person doesn't trust you, ask for further identification. You disclose you show your warrant. The person is entitled to read the warrant. After reading the warrant, you advise the person as to his right to counsel. If the person wishes, he gives you counsel of his choice. And that is done, then the person guides you throughout the search. And when you are done, you leave, and then that is procedure. And this particular procedure that I've outlined was followed. And we also have not been able to, the person whose home was searched has so far not raised any issues with us. So Dr. Addison has not raised any issues with national security, neither has he made any complaint to any state agency indicating that something untoward has happened.
Right.
So we the only time that we hear this is when the minority in parliament, speak. And we are willing, as a state institution, to accept any complaints and investigate them and make sure that people's rights have been, violated in the process, have been given proper remedy in accordance with law. So that is where we are at this point.
Right. Let's now move to the case concerning Dubois, the press conference addressed by your boss, the Attorney General, yesterday. The lawyers representing Kwabena Dubois, who is the former Director General of the National Signals Bureau, and his wife, they are accusing your boss of violating their client's right by publicly declaring them guilty before trial. Is that what you have done?
Again, I think I understand the concern that the minority has raised. It is not a proper thing to use state agencies or public power to harass citizens. It is not a good thing to use public power to execute citizens. It is not a good thing to use public power to violate the rights of citizens. So, and when state power is used, especially criminal procedures are commenced against a person, the key thing is that in our society in Ghana, whenever a policeman arrests you, you're already condemned in the eyes of the public that you're a criminal. I can't deny that fact. So anytime you come in touch with any police situation, you are likely to be tagged as a criminal regardless of the outcome of the investigation. So we are very much aware of that. So you will notice that for yesterday we made this press conference. And from the press conference, you would notice that this investigation has been going on for some weeks. And no one knew anything about it. We kept it because we know that when people hear that we are pursuing someone with a criminal justice system, they already will judge the person. Okay, so we are very much aware of that. We are also aware that when you are conducting investigations at this stage and you bring matters concerning the investigation out, it may mar or derail or even disrupt the investigation and make it sometimes even fruitless. So we are aware of that. So if you watch, we've been quiet on this until Monday. Secondly, you would also notice that anytime you hear of anything about investigations, as far as this oral project is concerned, it is not coming from the Office of Attorney General or any of the law enforcement agencies. It's coming from the minority. So, for example, if you take Dr. Addison's search, the search was done, we completed, we left. No one knew anything until the minority leader went to the house and took a picture with Dr. Addison and displayed it and made all manner of allegations about that. So the point I'm trying to make is that the Attorney General and all the agencies under the Attorney General, and indeed the President himself, we are not interested in using the criminal justice system to malign people's character, to harass them, or to persecute them. We will use the criminal system, justice system, to do exactly what it's designed for, that is to investigate crimes and prosecute those that we find culpable. Now, the reason I'm saying all this is that I understand the concern that the minority is raising. But what the minority is not addressing or is not looking at is this other side, that those of us who use public power, we have the mandate of the people, and whatever power we are using belongs to the people. And when you are working for people, you need to keep them updated. We call it transparency. In a democracy, you cannot have a meaningful democracy if you are not transparent. The people, you cannot have a meaningful democracy if you are not accountable. The people who give us power, we have told them that we are going to investigate crimes. We told them that we are going to recover loot. And it will be completely, wrong for us to ignore all our promises and ignore the values of transparency accountability and proceed as if we have powers of our own. It is in that spirit of transparency and accountability that we thought it wise to let the people of this country know that the work you have asked us to do, we are doing it, and this is how it has gone so far. So it is a balancing act between the private interest of the persons who have been, who have been investigated, and the interest of the public to know. One thing about democracy is that when you are not transparent and when you are not accountable, that is where propaganda can, prevail against you. So, for example, let's take this example. When we went to Dr. Addison's home, we took Dr. Addison's privacy into account by not coming public about anything that we did. And indeed, since January, our investigation, we have invited over 50 people. We have interrogated over 50 people. Many people have been arrested. We tried as much as possible to keep those things under wraps. So if I mention to you some of the people that that have been arrested, interrogated, and discharged, those people who are on bail, will be shocked. So we are very much aware of the private interest, but we also are aware of the public duty to be transparent. So we put these things together and we decided that, look, what we have discovered so far on this particular case, we should make public. So that is in no way, a disregard for a person's private, privacy or interest. And it is in no way trying people in public. In any case, the court itself is a public place, So the argument that when you announce to the public your findings of investigation and you inform them of what you want to do next, it is not fair if the minority is saying that amounts to trying people in the public opinion or court of public opinion. It is not fair and it is not right. And it is also not democratic to suggest that.
Deputy AG, we also have on the lines private legal practitioner Osman Al-Hassan. I'd like for you to hold on for me as I bring him into the conversation. Osman, thank you so much for joining us, Counsel. Are you also of the view that the comments by the Attorney General amounted to what people are describing as a public conviction while investigations were still ongoing?
Let me say good morning to the public and good morning to the Honorable Deputy Attorney General, my good friend. I don't think so, because as we all know, I agree in principle that public office, especially law enforcement bodies, should not use their offices to abuse the fundamental human rights of individuals. But it is always a dispute as to whether a particular conduct of a law enforcement officer actually, and in fact, abuses the fundamental human right of an accused person or a person against whom an offense is alleged illegally. Let's also agree, let me be quick to add, that the law has permitted the intrusion of public officers into our lives in manners that would otherwise be deemed as violation of our rights. And so, in a nutshell, let me say that there is a permitted violation of rights. And usually, this is done in comparison with a nobler cause. Something nobler can be the basis for which your individual rights may be violated, in quotes. And so, but coming back to what they are talking about, the actions of the Attorney General. Now, we have to understand that it is inevitable within our criminal jurisprudence that information or allegation about someone's wrongdoing or offense will come to the public domain at a point.
Right.
That is inevitable. Whether it is a charge in court, it becomes public. Whether it is an arrest, it becomes public.
Mm-hmm.
And let's an arrest. If you look at the procedure of an arrest in our criminal jurisprudence, the law enforcer is under a duty to touch you and to inform you of an allegation of a charge. In fact, the Constitution says in a language that you understand. And you see, the law didn't say the law enforcer should whisper this into your ear. And the law didn't restrict this action to any seclusion from public. So you can be arrested in public, and you can be told your charge in public. You see? And so if it turns out that you are not guilty of that offense, you don't turn around and say that your rights have been abused. No, it is an inevitable part of the process of taking you through the criminal procedure. Now, so if and I conclude on this, that at a point, information about you in respect of an allegation will be public. And for me, the time doesn't matter. Whether during arrest, whether in court, or in between the two, it really doesn't matter. Now, but as the Honorable Attorney General has said, transparency and accountability is very key.
Right.
And that ties very well with the right to information that is in the Constitution for all of us. And you would see that in the advancement of that principle of right to information, the Special Prosecutor's Office has been specifically mandated to update the public on the same work that it is doing as the Attorney General. And that's by law. And so if the Attorney General, who is even the main person to do these things, and is now giving someone that authority to do it on his behalf, is said not to have that right to update the public and to be accountable to the public, then it will be a travesty of that principle. The right to the to update the public, or the duty to update the public on what is going on. And let's say that, most of the time, I believe that what perception does is as dangerous as what reality does.
Right.
Public perception. Now, the Attorney General is wise to let us know that the public perception, which is always rife during these times, that any action of a law enforcer is deemed as a persecution of a political opponent. Now, these perceptions thrive in an environment of ignorance and opaqueness, non-transparency, because people don't have information about why someone is being arrested, about why someone is being investigated, about why someone is being treated in a particular way in the criminal proceedings. And so the Attorney General, and I will say that it is a bit novel, but it is positive, that they have taken upon themselves to inform the public why they are taking any action against any person.
Right.
Now, I said somewhere that, you see, it's also very important that as part of the rules of natural justice, the accused person should also even have the information about which the Attorney General or law enforcement body is accusing him, or the facts that are being alleged against him.
Yeah, but
and I said, when it is public like this, when it's public like this, the accused person or the person against whom the allegations are made also have the benefit of the information. Now, what I will tell you is that even now, I have a client, okay? And he is arrested. Allegations have been made against him. I need the information. I need the allegation made against my client.
Yeah, but counsel, in situations like this...
can you give me some time to do this?
Sure.
I need the person who has made the allegation. And I was told to go to the regional command of Ghana Police with a letter before I will be given that information. Meanwhile, as a matter of course, I am entitled to it in order to be able to prepare the defense of my client. I have gone for that authorization, paid money for that information, but for 2 weeks, I still don't have that information. You see? And so for me, the action of the Attorney General, the steps they are taking to update the public is in line with accountability, is in line with transparency, which are both positive in the advancement and development of democracy. Yes.
They are describing the posturing of the Attorney General that he is, prosecuting the matter in the court of public opinion even before it goes to court itself. But my question to you is, where do we draw the lines for probity and accountability and transparency, as well as not letting almost all the details in the matter out into the public domain? Now, if Adubuahin is your friend, if people know that Adubuahin is your friend, you're walking in town, people point fingers at you that, oh, this is the friend of Adubuahin, the man, people start calling him a thief, even though the matter has not gone to court for full-scale, investigation, conviction, all of that. Where do we draw the line?
Would this be possible even without any information given by the Attorney General or not? It would, because the arrest will be public. If you are arrested, wouldn't people be pointing fingers? And that's why I said it is the criminal process. There are certain things within the criminal procedure that makes it inevitable for some of these things to happen. Because if you are arrested in public and you are charged in public, that has the same effect you are talking about, even if the Attorney General doesn't want the podium to give information about why the arrest and why the charge. That is possible, isn't it?
Yes.
And so if the Attorney General now comes to give us information about why the arrest is effected, why the investigation is being made, or why a search is being conducted in a person's premises, is it not positive? Does it not feed into our perception against the perception of persecution instead of prosecution? For me, I think it is in the right direction. But let me sound this, if it is possible for anyone to make a conclusion from the statements that the Attorney General made, that the Attorney General has unjustifiably or even justifiably made conclusions of guilt of the accused person before trial by a competent court of jurisdiction, I might side with the person. But to the extent that the Attorney General is giving the public pure information, findings of fact, that is forming the basis for the actions or the next steps of the Attorney General, for me, it is in accordance with constitutional principle of people's right to have information, and it is positive because it dispels the perception of persecution against public opponents, and it advances our democracy in a positive way.
Counsel, good news does not travel as far as bad news does. In the event that, what I'm saying is, good news does not travel as far as bad news does. In the event that Adubuahin is cleared after the case goes to court and all that has to happen legally happens and he's found not guilty, how then will the AG department, if you like, undo what has happened to him in the court of public opinion?
But is the AG or any law enforcer under a duty to undo the effect of the actions they have taken to bring you to court to answer charges? Again, Are they expected to do the effect of public arrest and charge? No. That's why I'm saying that let's not mistake things that are necessary for any person to face a criminal charge in court to public prejudice about the guilt of an accused person. The two are different. You see, even if the public is not that legally educated to understand these distinctions, and for that matter, anytime an arrest is made, people have the perception that, okay, he is guilty of something. It is still permitted within the law for arrests and charges to be made, irrespective of those perceptions. And I don't think it is the duty of the Attorney General or any law enforcer to, after trial, in any event, even before the conviction, the arguments the Attorney General will make in court, the submissions it will make, the evidence it will adduce, and the charges, they are all allegations before conviction. So, if you say they should undo the effect by what? That they shouldn't have commenced the prosecutorial proceeding, or they should be convinced 100% that these things are going to secure conviction at all costs, and now become prophet giving prophecies of what the judges will say in fact. And if they fail in that prophecy, then they are guilty of some wrongdoing. No, I don't think that is what we have chosen for ourselves as the laws. And for me, as long as this constitutes transparency, accountability, and public information that dispels negative perception of persecution of public political opponents, and update the public, assure them that the Attorney General is conducting its duty in accordance with what they have given it. It is right, in my opinion.
I see. Briefly from you, you are a lawyer. You've been following issues like this. What should be the trajectory of the travel of these cases?
Ask that question again.
What I'm asking for is that from where you sit as a legal practitioner, in the face of what we know right now, how should this case of Adubuahin travel?
No, you can't push me into that. You want me to make conclusions of the end of the case
No.
It comes to an end?
No, counsel, no. That's not what we're asking. What we're asking for is, so right now we know what he's been accused of. From the perspective of a legal practitioner, what happens in the prosecution of these cases?
Yes, prosecution happens after gathering of evidence, and after the Attorney General has convinced itself that these are the required evidence, they meet the standard of proof, and they meet the requirements of the evidence rules, they mount the prosecution. And during the prosecution, what happens is that the Attorney General charges the person. The person answers the charge in the docket. And an application for bail might be applied, granted or otherwise. A date is fixed for the trial, and the trial will continue until, and in the course of time, the Attorney General, now the rule is that, well, you file what we call the witness statement, and the witness statement will now be served on the accused person or his lawyer, so they know the evidence and all that that are being adduced against them in court, and they prepare their defense. And so at that point, and that's why I was saying, at that point, even you and I can make an application to the court and say we need it. If they think it is one of the pieces of information that should not be in public, then they will give us reasons and deny us. Or if otherwise, they give it to us. And that's so this is what is going to happen. And if the judge if the judge sees that the charges or the evidence and the facts are consistent with the charges, and they meet the required standard beyond reasonable doubt, then of course the accused person will be convicted and sentenced. Except that if at a point, we know our criminal jurisprudence also make provision for an accused person to admit guilt, and pending the sentencing, after conviction and pending sentence, they can do what we call plea bargaining, so that if the offense involves recovery of some property, and the accused person is willing to restore that property, it is up to the prosecution to now take it and say that we would do away with the sentencing.
Right.
And if the courts agree, then they are left out. And it is better, because usually we want our property back. You see? So this is what we can all envisage moving forward with. But I understand that the Attorney General also says there's a need. The investigation is still ongoing, which means there's a likelihood that evidence might come to add to this one, and even change the position of Attorney General and lawyers about what should happen to the accused person.
Counsel, you just spoke about plea bargaining, and I'm reading a comment from a listener here, and what he's saying is that if the AG begins to dangle the idea of a plea bargain, doesn't it suggest a certain improper approach to the prosecution, possibly coercive or politically motivated?
Oh, the question is whether what the Attorney General is saying is true or false. If it is true, what's wrong with it? If it is true that there is a process of plea bargaining, which means that the accused person is admitting that, okay, I have done it, but I'm willing to restore whatever you think I have taken. What is wrong with that? Is it not good assurance to the public that indeed the Attorney General is working on its mandate? Yes, I think that's how I see it.
Osman, thank you so much for your time with us. We're grateful for your giving us your morning.
Most welcome, sir.
And that's Osman Al-Hassan. He's a private legal practitioner speaking with us there. Penny, it shares a similar name with the National Communication, the Bureau of National Communication, where he was the director in creating potential conflict of interest. This is where it gets interesting. So he and his wife, Madame Angela J. Boate, incorporated a private company in 2018, and they call that company BNC2, Communication Bureau Limited, referred to as Private BNC. You know that this company shares a similar name with the National BNC, the Bureau of National Communication, where he was director creating potential conflict of interest. So he established the company, named the company something similar to what was given to him officially by the state. Now back to the diversion of state funds. A total of 49 million cedis, and that is equivalent to $7 million, was transferred from the National BNC's account at Fidelity Bank to the private BNC account at UMB Bank under the pretext of paying for the software. So clearly you know that, well, they have the same name, so if you're not careful, you'll not see it. It gets interesting here. Only 9.5 million cedis, and that is about $1.75 million, was actually paid to the ISC Holdings. Remember that the ISC Holdings, this is the company where we're purchasing the software from, and this is something he was overseeing. The software was sold at $7 million. And that is a 49 million cedis equivalent. However, only 9.5 million cedis out of the 49 million cedis, and that is about $1.75 million, was actually paid to the original company that we're buying the thing from. the ISC holdings in Israel. The remaining 39.46 million cedis, the remaining $5.25 million, the AG says that it was used for personal gain. Apart from that, there's also the case of fraudulent documentation, that he submitted fake invoices and documents to justify the fund transfers. I already told you that the company established, BNC, has a similar name to the company of the country. Well, to the agency of the country, another BNC. So submitting fake invoices and documents to justify the fund transfers. There's also the bit about money laundering and suspicious transactions. The AG says money was moved through multiple banks, Fidelity Bank, UMB, Standard Bank, all in a suspicious way. He also made large cash withdrawals, including 16 million cedis, placed in fixed deposits from national BNC funds. And then some 7.25 million cedis withdrawn in cash. There's also some 1.5 million cedis used for real estate. And before we get into the response from the lawyers of Mr. and Mrs. Adubois, sisters, are you shocked? Are you surprised at anything?
Ghana we did.
Ghana you did. Mm-hmm. Nothing shocks you anymore.
Mm-hmm. But it's important to say that all of these things that we are seeing, these are allegations by the state. That is why our laws say that we should not condemn a man until after he's been tried, given a fair hearing. Mm-hmm. It is at that hearing that the man will say whether all of the things we are hearing from the AG about him are true or false. If the man insists that the things that are being said about him are false, then the man would have to sit back and watch the Attorney General go through the stress of convincing the court that indeed all of the things that the Attorney General is saying about the man are true. If the man says, well, what the Attorney General is saying is true, then the man would have just told the court that, look, do with me as you please, and the rest of it, the law will handle it. If the man says, well, some of the houses are mine, others are not mine. Some of the houses I use my salary to buy. Some of them, you can't come and tell me because I was a DG of...
I've earned my money.
I've earned my money. You were paying me 770,000 Ghana cedis a month. And out of that 770,000 Ghana cedis, I'm able to buy 2 houses every week.
Right.
And so, yes, that is how I acquired my 27 houses at Oyarifa. That is how I acquired my 6 or 7 or so properties at Mayfair. And so, well, what the Attorney General is saying, respectfully, is not true. Then the man will have won and the man would have freed himself. But until then, I mean, there's also this thing that we do about political appointees, politically exposed persons generally. Once it comes out in the news, we all go to town and we condemn the man before he is heard. I mean, in the spirit of the law.
The minority says that's what the AG is doing.
That is what has always been the case. It's not what...
But do you think that is what the AG is doing?
I'm not in the AG's department. I don't know what their strategy is. It's what we have seen from both political parties.
Okay. Hold on for me. Let's bring into the conversations Edem Senano. Is an anti-graft campaigner. Edem, thank you for joining us on the program. I'm sure you followed what the Attorney General said yesterday and the conversations that have happened afterwards. Are you surprised by any of the developments?
Well, I certainly am shocked at when you wake up and you're told that a single individual in 4 years got 27 houses and the value of those houses, you are wondering whether our systems are working. So that's a shocker for me because you can't get that happening without other persons in the network facilitating. And ideally, systems should have picked this up. You can't be registering companies in the same name, transferring millions, and it doesn't raise eyebrows. So there are lots of questions in that space. I'm a bit surprised that people are questioning the AG's actions. I mean, this is standard practice in the FBI offices regarding, for example, on the morning of filing charges against individuals in cases. They will call a press conference, typically in front of their own institution, and say, this is what we are doing this morning, these are the issues, etc. High-profile cases involving whether the president or attack on the country, they will again call a press conference. And others where they are just updating the citizens on progress made on cases. So this is nothing very new. Indeed, one of the major gaps we had identified with the terrain was that lack of feedback to the people of what is going on, feeding into the perception that corruption continues unabated with no actions. So in designing and crafting Act 959 for the special prosecutor, we inserted a clause that every 6 months at the ceiling, the special prosecutor needed to report back to Ghanaians. The intention wasn't that he has to wait for 6 months. It was to say, if you report more frequently to people, then there is that understanding that actions are being taken, and even those who are so inclined, it will serve as a deterrent. They will be less likely to think that they can get away with it.
The AG also said that we should, if you like, brace for impact, rumble in the jungle. What more do you expect?
Well, at least two levels. One, the nature of the compelling evidence, they should make sure that they have it, they've gotten it right. We don't want the situation like with Martin Amidu, where cases went to court. They didn't progress much further. So getting the acts, making sure they have all the evidence available is important. On the other hand, also retrieving, and that's where for me coming out early perhaps also has value, because you see, you suddenly get 30 million Ghanaians with their eyes open, ears on the ground, looking out for any other such untoward action. It makes it very difficult for people to hide resources or to transfer them or move them. It's important, and we usually see prevention is much more important than prosecution in the anti-graft space. How do we make sure we retrieve as much of that assets? I mean, 27 houses, we know where the houses are. That's good. That's probably low-hanging fruit. So striking that balance to make sure we are retrieving as much of the resources that can be put to work for this nation is the other expectation I would have. I was just saying on another platform that, look, other jurisdictions have even put in place targets these days in the anti-corruption space, where they say, I think in Kenya, with 6 months, they want to see results on anti-corruption cases. So we should also see how quickly we can get these things into rulings out of the court.
They're also already calling for some forms of tribunals to deal with the matters that are before the oral committee, so that we see some haste in, delivering judgment and reaching finality to these cases. Do you support them?
I am not properly seized with how the tribunal system works, and so I'm kind of neutral because I'm not quite sure the rationale that this government is standing on to say tribunals will deliver the results we want to see or the outcomes. I'm clear in my mind that in various parts of East Africa, specialized anti-corruption courts where the judges, prosecutors, bailies, everyone in the system understands the terrain and what is required, and so they are getting faster results, setting then make it unlikely or less likely for people to think that this impunity should continue. It's working. And so there is an evidence-based result that I can speak to. So I would hesitate at this point to talk about the tribunal system and what it might offer. But I would say we do need specialized anti-corruption courts. We should focus much more on plea bargaining and other, community sanctions, things that will allow us to be pragmatic and move forward, get the resources back, plowing it back in our economy. I think that is what I can speak to for now.
Adam, let's go back to the Dubois case and the presser by the Attorney General. A lot of details were revealed by the Attorney General yesterday. What do you say to those who are of the opinion that the approach by the Attorney General will be difficult for the Attorney General to handle? I mean, to undo the damages that it may inadvertently cause to Mr. Dubois if it happens that he's not guilty before a court?
I don't think that, let me start first with a personal opinion. I mean, listening to what the AG said, there are major questions, and if this does not already point to some criminality, then I don't know what will. If you collect money in the name of the state for particular purposes, and a certain amounts become your own amount, that's very questionable. That already says something has happened. I think on the surface of it, every right-minded citizen will say, no, but that's not right. Having said that, I think the beauty of the way the AG approached it was that he was open to questions. So he provided facts, and then we had the opportunity to ask the questions. And
so with the personal experience that you shared, saying that if this does not amount to a crime, does that not sound too prejudicial?
Sorry, come again.
When you were attempting to one side, you said if this does not amount to a crime. What I'm asking, does it not seem too prejudicial?
I think that you need to pay attention to the preamble. I said if money is due to the state and an individual who is not entitled to it then begins to take that and enriching themselves, isn't that criminal? Right. So I don't think there's any doubt about that. The preamble is what is very key.
Right.
And that's the point I'm making. That look, if money belongs to the public, and you are not entitled to it, that's what we call corruption, by the way. The abuse of entrusted power for personal. The rest of us, we nominate you to represent us in a position. And in that position, you're supposed to facilitate the resources of the state for all of us to benefit. But when you begin to take advantage, exploit that position to make sure that you, your wife, your family benefit at the expense of the rest, it's corruption. Classic. So, whichever way, I'm clear in my mind, and maybe it's the space I occupy, that something very wrong has gone on. And the debate about what happens if you're not, if a court is not able to, especially if we are right that this money belongs to the state. If they put that no, the money didn't belong to the state, then obviously the preamble goes and then the conclusions are wrong. But to the extent that this is money that was supposed to come to the state, and then some individual begins to benefit, and you can see the intention taken to have money paid into certain accounts, etc. This is black and white in my mind, and I'm not going to differ about calling it a crime if the premises is right.
Looking at the other cases that the Attorney General spoke about, for instance, the former National Service CEO allegedly paying an MP to kill the ghost name scandal. It talks a lot more about political involvement in corruption and how we deal with them. Mind you, this is not the first time that a member of parliament has been mentioned in corruption allegations. You remember the claim by Mandia Piakubi that a businessman tried to approach MPs, to offer them money over the Ken Oforiatta issue. How do we manage such situations?
Well, many of those leaders come out from us. And so there's a sense in which what we are seeing is a reflection of what is happening in our society. It tells you that we need to be a lot more cautious in selecting those who we want to represent us, and a lot more intentional in perhaps checking their historical records, their track record of being persons of integrity, of honest and hard work, and being able to deliver on whichever mandates they are given. I think that at this moment, Ghana sorely needs persons of honesty and integrity to be appointed into these positions if we are to see a change and get good results. And I don't think it is the case that we lack them. I think that sometimes the political class simply choose from them or their own family and friends without paying attention to certain criteria that would make the difference. Hopefully, as we develop a political culture where, yes, we may have 11 people on the playing field, but we determine who is a striker. We determine who the strikers are, the ones who must score those goals, because we know they have the capacity, they have a track record of doing same, and they are definitely going to help us get there. I think we need to be a lot more intentional in doing our due diligence, in selecting people with a proven track record into these positions, in strengthening the monitoring systems, because I'm clear in my mind that some of the actions, creating accounts that have the same name or companies that have the same name, should have raised eyebrows at the Registrar General, should have raised eyebrows within the bank. Our banking system doesn't allow you to just cash in millions of. How did that happen? He must have raised eyebrows. So what is it in our current monitoring systems that allow this to happen without being, stopped? That's how we strengthen systems. I have an industry background. We see that anything that happens, you have just two opportunities, in fact, 3 opportunities. The third time you get fired. So we're trained to make sure it happens first time, you find a solution. It happens second time, means your solution is not working. Remedy it. You are not allowed to have a third failure in the same space. And that made us very, rigorous in upfront thinking, advanced planning. And that's what we need to do. If this has transpired, a very worthy discussion is what let this happen. There clearly has been a systems failure. It shouldn't always have to be the subsequent government that comes in. Even that is part of accountability architecture, and it's fine. We should not start talking about witch hunting. If it's going to change the previous government, that's part of good governance architecture. But we clearly have had systems failure in the space.
I see. Adam Senanu, thank you. Thank you so much for your time with us on the program. Have a great morning. Adam Senanu speaking with us. There is an anti-graft campaigner.